Hi, Sandy Anderson here. I'm just continuing my best explanation of parental rights in the state of Kansas, specifically for USD 323 Rock Creek. Again, I stated in the first video that I am not a lawyer, nor do I claim to be. I'm just simply trying to do my best to understand parental rights so I can help you be the best advocate for your child. So please know that you should do your own investigations and learn more about this on your own, and hopefully I can help you point you in the right direction, as well as just kind of to explain a few things. So we were discussing your parent rights that you have to receive notice of IEP meetings. That notice must be written. It must be given 10 days prior to the meeting, and there must be agreed upon times, dates, locations. It must state what the purpose of the meeting is. It must also state who the school will have in attendance of that meeting. If there are any specialists or professionals that could provide relevant conversations for the well-being of the child, they can be included in that, as well as the parent can also bring their own resources, possibly a therapist, grandparents, just anybody who can help enrich that team to do what is best for students. There can also be early childhood attendees. So if a child was attending preschool and they are transitioning into kindergarten, that early childhood representative is welcome in that meeting as well to kind of help make that transition a little bit smoother. And then students, once they turn 18 years of age, they are also invited to those meetings. They must actually be notified when they're 17 that they have that right, but they must also receive written notice of the IEP meeting. Then thinking further into the next set of kind of how to dive into these parental rights would include rights for parents of gifted students. They have the same rights as parents of students with disabilities, with the exception of the following. There's not disciplinary protections. Children who are under the age of 5 are not eligible to receive gifted services. Least restrictive environment is usually not in consideration on an IEP of a gifted student, but the entire individualized education plan should all be based on what those students' individual needs are, and so it might involve a different setting. Not eligible for all services. Gifted students are not eligible for all of the same services that those with a disability might be. And then juvenile detention centers, as well as Department of Correction facilities, they do not receive gifted services, and so that does not flow over. If the student is in one of those institutions, they would not be able to receive gifted services. And then there's no requirements for secondary transition. And so after a student graduates, there isn't a requirement to have a transitional meeting for those gifted students. The next slide considers who educational advocates are. They are appointed only if parents are unknown, unavailable, or the rights have been severed. And so educational advocates are those that would stand in those instances in which the parents are unknown, unavailable, or the rights have been severed. They must be appointed by the State Board of Education. They cannot be employees of the agency or be a part of the agency's IEP team. They cannot be an employee of the state board or department. They cannot be any person with professional or personal interest that might conflict what is best for that student. And foster parents must be appointed to that role. They can be appointed, but it's not implied that just because there's a foster parent that they're the educational advocate that has to be appointed into the role. There are specific trainings that must occur in order to be considered an educational advocate. So if that's something you need to look further into, click on the website at the end of this slideshow and you can learn a little bit more about that. And then finally, we talk about students' rights at the age of 18. And so a student must be informed of rights on or before their 17th birthday. And once that student turns 18, all parent rights transfer to that student. Parents can be included on that individualized education plan at that point, but it is no longer a right. That is the right of the student, and all of those transfer directly over to them. And so something good to consider with post-secondary as you transition into college that you can be a part of, but it's not your legal right. So that, in summary, is just kind of an overview of the different parental rights in special education in the state of Kansas. Again, as I've recommended several times, please take the time to go through and read this yourself. It can be an overwhelming document, but I really hope that I've kind of given you an overview of those different components to look for and what your parental rights look like in special education in Kansas. Again, within our website, you can go to USD320.com and click on the Special Services Co-op to find more links for information in how to better support your child and to know your rights and how to advocate for your child. Also, feel free to respond on this thread and let me know any questions that you might have, and I will do my best to answer them, or at least to find someone highly qualified to answer those questions for you. So thank you for listening and have an amazing day.